with the evidence that we have. Yeah, Steve?
Is this going to be limited by a Stogner type situation where if the statute of limitations are
Exactly right. And it specifically says in the statute that it applies to all crimes committed on or after January 1st of 2017 or any crime whose statute of limitations has not yet run as of January 1st, 2017. As we learned from the U.S. Supreme Court in Stogner, you cannot revive what was the word I used? A time bar, thank you. You cannot revive a time-barred prosecution. But, you know, we have a lot of other existing sections. We have, you know, for example, there may be plenty of crimes that are really old that we can prosecute now, such as under 801.1a. You know, we can prosecute a crime committed when the victim was under 18, any time before the victim's 40th birthday. We have the 10-year statute of limitations for many felonies in 801.1b. Penal Code 803F, we can file a criminal complaint within 1 year of a report to law enforcement that a person of any age, but a person was a victim of a certain crime while under age 18. And then 803G, for any crime specified in 290C, our list of registrable sex offenses, we can file a criminal complaint within 1 year of the date that the identity of the suspect is established by DNA testing. So there's a whole lot of ways that many statutes as of January 1st, 2017, will not have run. So it could be that we have a case on January 1st, 2017 we don't even know about, where the victim is 39 on January 1st, 2017, was victimized at age 15, but doesn't come forward until 6 years from now. Well, we can charge that now, because on January 1st, 2017, that statute had not run because 801.1a applied. So that's how we're going to get, we could get pretty soon some really old cases that don't necessarily fit any of the existing statute of limitations that we have. But there you go, another bright spot for law enforcement. Let's go to page 139 and talk about 859.5 of the Penal Code. And this expands to adults the requirement to electronically record the custodial interrogation of a murder suspect who is in a fixed place of detention. Now, effective January 1st of 2014, we got this section that only applied to juveniles. It was created by 2013 legislation. It has a slew of exceptions that all apply to adults as well. And it only applies if the suspect is in a fixed place of detention, such as in a interview room at the police department or the jail would be a fixed place of detention, arguably. A crook being driven from the murder scene in a police car to the jail is arguably not in a fixed place of detention. But there are a number of exceptions, such as the guy says he doesn't want to be, or she, the gal, does not want to be recorded. You have no idea murder's even going to come up in the conversation because you're talking to the guy about burglary. And all of a sudden murder comes up, start recording. So we need to be really mindful of this so we don't spend months litigating this stuff. I mean, ideally every murder interrogation would be recorded. It should be standard practice because it's a good practice. It continues to require that the custodial interrogation of a juvenile murder suspect be video recorded, but requires only audio for adults, but encourages video wherever available. Let's go to page 142. Penal Code 993. This requires the court at the arraignment of a defendant charged with a felony, page 142, who the court reasonably deems to be the sole custodial parent of at least one minor child, to provide a bunch of information for the parent about guardianship, about power of attorney for the minor child, about trust line background checks for child care providers. The idea is to put some hands on the information, and to put information into the hands of a defendant who is a sole custodial parent and may need help with child care. Now, this doesn't tell you or tell me how a court's going to reasonably deem it. So it seems to me that the court should incorporate into its arraignment speech one or two sentences, simply telling everybody in the courtroom, if you're the sole custodial parent of a minor child, you know, tell your attorney, I will give you the papers. Probably the easiest way to do it. Otherwise, the court's not going to have any reasonable way to deem that unless attorneys start asking their clients about that or start proactively doing it on their own. Let's mention this one briefly. 1000.7, page 143, limits to 1 year. authorizes several counties, including us, to establish a 3-year deferred entry of judgment pilot program. Interesting program. It would be within our county juvenile hall for adults aged 18, 19, and 20. I don't know if we're going to do that or not, but it's interesting because it requires these 18, 19, and 20-year-olds to be completely separated from the juveniles, the under 18 crowd who are in juvenile hall. So really interesting. Don't know whether we're going to do that, but I'm pointing it out. So if you hear something about it, you'll know you heard it here first. 1026 of the Penal Code, page 145. This is part of several sections of this bill, SB 955, that create a compassionate release program for offenders who are found not guilty by reason of insanity, offenders who are mentally disordered, offenders NDOs, offenders who are incompetent to stand trial. And compassionate release, this is very similar to 1170E compassionate release, where inmates in state prison are either terminally ill with 6 months or less to live, or they are permanently medically incapacitated. The overall section that creates this program is WNI Welfare Institutions Code 4146, and then it amends or adds a section in each area of the Penal Code for the specific offender. So Penal Code 1026 has to do with those found not guilty by reason of insanity. Penal Code 2977 is a new code section having to do with the mentally disordered offenders, and Penal Code 1370.015 are those found incompetent. So it'll be interesting to see if we have more compassionate release. It's certainly been expanded the last few years. 1048.1, furthering our theme of human trafficking. That's the next one. 1048.1 adds offenses against persons with developmental disabilities to the list of crimes where the trial date should avoid being set on the date of the prosecutor for that case. There's another trial set. This is so that our prosecutors can develop a relationship with vulnerable victims and not have to hand off the case at the last minute. 1048.2 of the Penal Code on page 146. This allows the court in its discretion to grant priority to human trafficking cases over other criminal cases. 1170 of the Penal Code, interesting changes here. It eliminates the long time declaration in section 11C. Instead of reading the purpose of imprisonment for crime is punishment, and replaces it with a declaration that the purpose is of sentencing is public safety achieved through punishment, rehabilitation, and restorative justice. It also eliminates the last sentence of A1 of 1170, that uniformity of sentencing and elimination of disparity is best achieved by determinate sentences. Now, most of you weren't even alive probably in the 1970s when we went from indeterminate sentencing to determinate sentencing, and that time it was felt like we didn't have any truth in sentencing. People were being let out of jail or let out of prison very early for serious rapes, murders, and things like that. So determinate sentencing came into place, and slowly sentences started to climb. We had a certain range of sentence, and now we have pretty huge sentences for sexual assault crimes, including life crimes. But the thought was that if we had determinate sentencing, there would be a specific amount of time that you have to serve, and the legislature would decide what the range of punishment is for this particular crime. It would be even, across the board for people who commit similar crimes, and they would be treated similarly. So they've eliminated this now with Prop 57 coming into place, and the prison authorities now fashioning regulations to get more people out early, to give more people credit for time served. Is almost as if we are going back to the system we had in the 1970s. It'll be very interesting to see how all of that plays out over the next year or so as these regulations are adopted and put into effect. Let's go to page 149, 1170.1. All of those sections that you deal with sentencing-wise would say that the court can select any one of 3 terms when a crime offers 3 terms. They are still in effect. We have a 5-year extension on the sunset date on those sections. So we're not going to go back anytime soon to the version of those sections saying that the presumptive term is a middle term. It's a middle term because that violates the defendant's right to a jury trial, as we learned in the U.S. Supreme Court case of Cunningham. So rather than just deleting the sunset date altogether, we every few years have to fashion a new bill to try to get the sunset date further extended so that we don't have to try aggravating factors to a jury. 1170.18, you will be seeing Prop 47 petitions for some time to come. They've extended By 5 years, the deadline date for folks to file their Prop 47 reduction petitions is November 4th of 2022. Let's go over to 1203.065, another huge bright spot, and the credit here goes to Jeff Rosen on this one, finding an author to carry this bill and seeing it through. This adds several sexual assault crimes to the list of convictions that make a defendant absolutely ineligible for probation and mandatorily require a sentence to state prison. Rape by all the intoxicating, unconscious sexual assault crimes. In the rape statute 261, sodomy 286, oral copulation 288A, and 289 sexual penetration. And of course we were helped along on this by the what many felt was the lenient sentence handed down to the Stanford swimmer, and it caused a lot of public outrage. But sometimes that's what it takes to get something pro-law enforcement through the legislature sometimes. And so that did it. 1203.35, you may be hearing about flash incarceration. I'm really going to talk to probation more about this than you folks, because you're not really involved with flash incarceration. Just be aware that there's now a mechanism for the probation officers to use flash incarceration for both probationers and folks on mandatory supervision, but it is extremely odd, very oddly written, and I would argue very poorly written, because it actually allows the supervisee to veto the flash incarceration. So if I'm being sentenced today, the judge is going to ask me, do you waive your right to have a hearing on flash incarceration? And I may or may not say yes to that. Even if I say no, I'm not going to waive my right to a hearing on flash incarceration. The judge still has to grant me probation. He can't say, I'm not going to give you, or she, I'm not going to give you probation because you won't waive that. But then when it comes down to me violating my mandatory supervision or my probation, and my probation officer says, I'm going to put you in jail for 3 days, not on the weekend, so you're not going to have your job messed with, of flash incarceration, I can then say no, file a petition instead. So this is very different from the flash incarceration we have for parolees and for folks on post-release community supervision. And I really am wondering how this is going to work. Of course, there's nothing that prohibits a probation officer from hooking up a violator right on the spot. If I'm a probation officer and the violator says, no, I don't want 3 days of flash incarceration, I'll say, fine, I'm going to hook you up and I'll file the petition, no problem. And then that person's probably going to be in jail a good 2 weeks before getting to court, and well, maybe not 2 weeks, but it's going to take some time to get to court, to get before a judge. And the judge may say, well, I'm going to put it over and think about it, whether I'm going to release you or set a hearing date or whatever. So we'll have to see how probation handles that. It'll be up to them to figure out how to do that. I just thought it was an extremely odd section. Let's go to page 157. Those of you who deal in bail forfeiture motions, page 157, 1305.3, know that our fees, the money we spend on your salaries to write up motions, to oppose a bail forfeiture, time you spend in court on these things, is now part of the costs that we can get out of that forfeited bail money. So keep that in mind. There was a case, People versus U.S. Fire Insurance Company, that found that the word costs in 1305.3 did not include our attorney's fees, and invited the legislature to fix it, and the legislature took up that invitation. 1347.1, if you are interested in having a minor testify via closed circuit television, be aware that if your minor is 15 years of age or younger, and testifying in a human trafficking case, you can do that in closed circuit, with closed circuit television. Now, rather than just amending, this is identical to our existing 1347 that allows minors age 13 and younger to testify via closed circuit in sexual assault cases and violent felonies, child endangerment, physical child abuse, and so forth. Rather than just adding age 15 and younger in human trafficking cases, they created an entirely new section, 1347.1. Okay, I'm going to skip a bunch of stuff right now because I want to get to Tom Flattery's stuff. So let's have Tom come on up here. And he's going to be talking about the pen register and trap and trace, and page 166 to 169, everything about the California Electronic Communications Privacy Act. And Tom deserves a lot of credit on this. He worked very hard to try to make this thing somewhat livable for law enforcement, getting a lot of good things fixed that those who drafted this last year and forced it through the legislature really haven't thought about, like 911 calls. And what about people on probation and stuff like that? So thank you, Tom, for working so hard.
Before I talk about Cali CPA, the SB 1993, also on page 166, one of the biggest problems in dealing with these service providers has been how does law enforcement actually contact these guys? So AB 1993 added PC 1524.4, which, can everybody hear me?
You need to make sure you're heard on
Okay.
on it.
Okay, AB 1993 added Penal Code 1524.4, which requires companies that are under the control of Cali CPA to file a statement with the Attorney General that describes a process how they can be contacted by law enforcement. That process has to tell law enforcement how to get in touch with them. It has to be continually available, and it has to provide law enforcement an ability to get a status report on their search warrants or subpoenas. By July 1st, they have to file that statement with the AG, and the AG will distribute that to local law enforcement. The current plan by the AG is to use a publicly available website, kind of like search.org, but it'll be California only and only California service providers. I don't know that that will actually happen because subdivision E of 1524.4 says that the statement and anything distributed is confidential and not disclosed pursuant to a Public Records Act request. So stay tuned about how we'll get that information, but it's going to be there. Now, lots of changes to Cali CPA. Senate Bill 1121 amended several things, including ways that you can directly access electronic devices. The most important one is going to be probation and parole. So for people on parole or post-release community supervision, after January 1st, you'll be able to search their electronic devices exactly as you could have before Cali CPA. No limitation. For people on probation, pretrial release, or mandatory supervision, you can search their electronic devices just like before Cali CPA if there's a specific search condition that includes electronic devices as a condition of their release. That's not a lot different than it would have been. That's the way the case law was going anyway. So how will the cops in the street know if there's a search condition? That's yet to be determined. They're going to have to basically call the on-duty probation officer to figure it out. 911 calls, as Kathy said, are now outside of Cali CPA if you access them or get information from a third party related to the phone number or the location of the device. You don't have to get a warrant. You don't have to go to a judge to get a judge to agree that there was an emergency. You don't have to notify anybody. If the call comes in from something other than the 911 system, all the normal Cali CPA rules apply. So if a suicidal person, missing person, comes from a non-emergency line and you need to ping that person's phone, then you have to get to a court within 3, it's going to be court days, and notify the person once you get the information. There's a change in the way we treat phones recovered from custodial facilities. Before this year, we could search a device found on an inmate or found abandoned in a facility under the supervision of the Department of Corrections, the California Department of Corrections prison. An abandoned phone in local county jail required a warrant. This amendment now includes local detention facilities. As long as the phone is not found, is found in an area that an inmate had access and not reasonably believed to have been lost by or left by an authorized visitor. That still leaves out probably juvenile facilities and state hospitals because it specifically says a detention facility and those other things aren't defined as detention facilities. There's also an exception now that carves out the magnetic stripe on a driver's license, a state-issued driver's license or ID, from the definition of an electronic device. The reason for that change was so officers could use e-ticket readers or populate an intoxilizer machine by swiping a driver's license. It specifically excludes, or it doesn't mention rather, other magnetic stripes like a credit card or school ID or a hotel key. So our best interpretation now, especially given this amendment, is that those other magnetic stripes do fit within Cali CPA. And then there was a separate bill, SB 840, that included smart meters as an exception within Cali CPA. So you can read a smart meter, government can read a smart meter without a search warrant. Cali CPA also changed some of the rules on the use of a GPS tracker or a tracking device. It added an exception for a tracker warrant within Cali CPA, and that mostly is going to deal with when you get location information from a third-party provider. Say you want to get a ping warrant for Verizon to tell us where the fella is located. Those now are authorized within Cali CPA, and all of the Cali CPA rules apply. But along with that, they changed some of the rules with normal tracker warrants. So before this amendment, if you used a normal tracker warrant, you slapped a tracker on a guy's car, the rule was you had to notify the guy by giving him a copy of the warrant within 10 days after you ended the tracking. Now that's changed. You still notify them within 10 days, but the notice has to comply with Cali CPA. So that means in addition to giving them the copy of the warrant, you also have to give them a written statement basically telling them what the investigation is about. Before this amendment, if you wanted to delay that notice, the court had discretion to give you a delay for as long as they wanted, and it could be based on good cause. Now the delay has to follow Cali CPA, which means the delay is limited to 90 days, and it has to be based on the Cali CPA definition of adverse result. Let me jump ahead and talk about the trap and trace and the ping warrant, or the trap and trace and the pen register. You remember last year, Kathy talked about the new law that for the first time authorized California to use a trap and trace order or a pen register order. The problem was that Cali CPA did not authorize the use of that order, so our interpretation was that you couldn't use the California trap and trace or pen register. There's AB 1924 now added that order as a new exception to Cali CPA, so you can use a trap and trace and pen register. But that also changed some of the notice requirements that had been included in the trap and trace and pen register order. Before, law enforcement was not required to notify the suspect at all, and there was a sealing order during the use of the trap and trace that, again, the court had discretion to give as long as it wanted and for good cause. So now, the sealing order has to, again, match Cali CPA. And the default sealing order for the service provider is for the length of the monitoring. The law enforcement has to notify the person that was monitored within 30 days of ending the trap and trace or pen register. So you have to notify the target according to everything that was in Cali CPA within 30 days, but the service provider is free to notify as soon as the monitoring ends. So if you want to delay that order, you need to get that delay before the monitoring ends for the service provider, or you have 30 days yourself to get that delay order. And it also adds the universal suppression remedy with universal standing for pen registers and trap and trace. So when you take that together with the tracker warrant changes, you get basically 5 different schemes. If you want past content, past call detail records, or past location history, you need a Cali CPA warrant. Everything applies, Cali CPA applies. If you want future call detail records, future metadata, what was the phone number dialed to, who was it dialed, you need a pen register and trap and trace order, but with that order, you can't get location, you can't get content. If you want future location, you need a ping warrant that fits Cali CPA, but you can't, with a ping warrant, you can't get call detail records and you can't get content. If you want future location with an agency-owned tracker, then our best interpretation now is that Cali CPA does not control that warrant. You still need a warrant, doesn't have to be a Cali's EPA warrant. And if you want future content, of course you need a wiretap. So there's going to be a different order depending on what you want. There's no reason it can't be the same document that contains all of those orders, but you need to understand what you're looking for and make sure you spell out exactly why it's all separate and different. There's also changes to the format of a Cali CPA warrant. You know, in the past, every warrant had to include a time period. Now it says you only need a time period as appropriate and reasonable. I'll tell you that because you still have to be particular in the description of what you want to seize, most of your warrants are still going to contain a time period. But there's going to be situations, specific situations, where a time period is not appropriate. Maybe it's because you're looking for deleted data where the time period is scrubbed from the data when it's deleted. Or maybe it's because you're looking for child porn where you don't care when you looked at it. Spell out in the affidavit why you're asking to not be limited by a time period and get specific authorization in the warrant, and now that's also authorized. And another important thing for us, before this amendment, information unrelated to the objective of the warrant had to be sealed and not accessed again without a court order. One of the bases for the court giving that order is if disclosure was required by state and federal law, basically Brady or 1054. So technically, you needed a court order to provide a full copy of the suspect's own cell phone dump to the suspect's attorney. This amendment says now there is an additional basis for disclosure absent a court order if the disclosure is required to comply with 1054. Now, the important thing here is that means you have to go back and look at the information for exculpatory information. That's okay because that's required by 1054. But if you want to go back and look for inculpatory information, you need a new warrant. There's additional authority related to jail phone calls. The question was, does Cali CPA even apply to jail phone calls? And we still kind of don't know, but there's additional authority. If the disclosure, if there's voluntary disclosure from a service provider that either is a custodial facility or discloses to a custodial facility, you don't have to get court permission to keep it within 90 days if there was a recorded message where all parties to the communication were told before the communication that it may be disclosed to the government. So what does that mean? We kind of don't know. If our recording doesn't include an advisement that this recording may be disclosed to the government, then you're back to the default rule. You need to get court permission to keep it within 90 days if you view the jail as a service provider. But my buddy Jeff here got a great decision from one of our local judges that says Cali CPA doesn't even apply because the jail is an intended recipient of the communication, and an intended recipient can share the communication absent Cali CPA. We don't know how that's actually going to play out. So just be aware and talk to Jeff. There's another change to allow the government to reclaim government-owned electronic devices in the possession of an employee. There was a question about whether a police body cam could be searched by the agency if the police officer withdrew consent to search a device in their possession. The way they fixed that is to just say an employer can reclaim the device. Now the employer is in possession of the device and can consent. In several places they changed 3 days, 3 calendar days, to 3 court days. Specifically, if you get information in an emergency, you have to get a court to agree that it was an emergency, now within 3 court days instead of 3 calendar days. Just worked out that we had this discussion with the authors on a Thursday before a Friday holiday, so it just made sense. They understood what we were talking about. The one place that did not change is that if you get information in an emergency and you don't know the target, you still have to notify the Department of Justice. And you do that through an online web portal. And since that web portal is never off-duty, there's no reason to extend the time period to notify DOJ if you don't know the target. So that's still limited to 3 calendar days. And that's it.
Thank you very much, Tom. Let's go to page 172. And we have about 12 more things to talk about, and then you're out of here. 172. And talk about 2900.5, our credits section. This clarifies that when a defendant serves time in jail to serve out fines at the rate of not less than $125 a day. It used to be $30 a day, and then it was up to $125 a couple of years ago. It's only the amount of the base fine the defendant has to serve out, not the total fine with the 200 to 300% penalties or whatever it is now. So keep that in mind. According to legislative history, the legislature felt that some judges were making people serve out the entire base fine plus all the penalties. So in other words, it's really less time that someone will have to serve if they're serving out fines. We're going to skip a bunch of stuff and go to page 190 and talk about proposition, no, we're talking about leaving handguns in cars. That's what we're going to talk about. Page 190, Penal Code 25140. And this is a new infraction crime of leaving a handgun in an unattended vehicle and failing to either lock the handgun in the trunk or lock it in a locked container and place the container out of view, or lock the handgun in a locked container and that container is permanently affixed to the vehicle's interior and not in plain view. Infraction punishable by up to $1,000. Actually, yes, we're right, it's not punishable by jail, it's just a fine crime, so keep that in mind, 25140. Of course, if the person is a felon and shouldn't have a gun in the first place, you're going to be charging Penal Code 29800 or something like that. But for the average, otherwise law-abiding citizen who can have a gun but is not leaving it properly, this infraction might be appropriate. Penal Code 25250 and following, bottom of page 190. In 6 or so months, July 1st, 2017, 7 months, this is the new infraction or misdemeanor crime of an owner or possessor of a firearm failing to report the loss or theft to law enforcement within 5 days of knowing or reasonably should have known that it was stolen. So that's Prop 63, and that crime starts July 1st, 2017. So the bottom line is you got to report stolen or lost firearms. The government wants to know about that. And in 25250B, the first one was subdivision A. Subdivision B is the new infraction or misdemeanor crime of failing to notify law enforcement within 5 days if the item is recovered. So you got to report it when it's stolen or lost, but then if you find it, or somehow it's recovered, then you need to report that too. Now, first and second violations are infractions. When you get to the third or subsequent, that's when it can be a misdemeanor punishable by up to 6 months in jail. Page 195. Talk about 29180 to 29184. Any of you who are involved in manufacturing your own guns, be aware that you need to apply to the Department of Justice for a unique serial number or identification mark. This is what's called the ghost gun bill. They don't want guns out there without identifying marks or serial numbers. So beginning, this is a year and a half delayed effective date, July 1st, 2018, anybody who wants to make or manufacture a gun has got to apply to DOJ for that unique serial number and put it on the gun. Page 197, 29180, another delayed effective date, page 197. And this is 29810, not to be confused with ghost guns, which is 29180. This is 29810. In a year, we will have a system whereby anyone convicted of a felony or a misdemeanor that prohibits that person from having a gun for 10 years, so anyone who would be subject to 29800 of the Penal Code or 29805, anyone who can't have a gun under those sections will have to relinquish firearms upon conviction. And this sets forth a very long, complicated, cumbersome process about how the court and probation are going to go about trying to make sure that people relinquish their guns. The bottom line is, unless we know that a gun is registered to someone, it's going to be very difficult, even with this process, to know whether someone has relinquished their gun or not. So I will not go over all the details here. I just want to make you aware of that in case you're in court on January 2nd, 2018, and somebody starts talking about relinquishing of firearms and why it's not discussed in the probation officer's report. Because they have to discuss it in the report, the court has to make certain findings. If the court feels like there's probable cause that the defendant has not relinquished firearms, the court may authorize a search warrant for law enforcement to go find those firearms. Let's go to page 206 and talk about 30370. There are a lot of firearm provisions that are somewhat complicated in Proposition 63 because there were 4 or 5 bills in the legislature that also amended same sections or created some of the same sections that Prop 63 created. So we're not entirely sure what's really going to be effective. And the biggest issue for me is this 30370 on page 206. Prop 63 has a version of how ammunition purchases will work beginning January 1st, 2019. And Senate Bill 1235, which tried to amend Prop 63, has a different way that we're going to handle ammunition purchase authorization starting July 1st, 2019. So the bottom line is if you want ammunition without a lot of hassle, go buy it now. I was in Big Five the other day buying, not ammunition, buying some softball socks for my daughter. And I just happened to ask the guy, because they sell guns and ammunition. I said, have you had a run on ammunition? He said, oh yeah. Oh yeah. People are stocking up on ammunition. It's either going to be that you have to, under Prop 63's version, you apply to DOJ for a permit that will be valid for up to 4 years. And I'm assuming you would then show your permit wherever you want to buy ammunition. Or the easier way is really the Senate bill way. What the Senate bill does is it repeals Prop 63's version, and it creates its own new version, which will have the authorization done at the time of the sale. So you go in there, you hand over your ID, the seller uses some computer database or does something or other and figures out whether you're authorized to buy ammunition. That actually sounds a lot simpler. So I think probably all we're really going to have to do is wait and see what DOJ does. Because either they'll tell us they have the system up and running for retailers to check, or they're going to tell people, you got to start applying to us for your authorization to purchase ammunition. So I don't know whether there'll be litigation over which one prevails. I know there was some disgruntlement among Prop 63 supporters that the legislature did SB 1235, which did amend some Prop 63 provisions. Before Prop 63 was even in effect, this bill was signed into law by the governor. So we're just going to have to wait and see, but I have a feeling that it will all become clear when DOJ figures out what's the easiest thing and the least cost way for them to handle the ammunition purchase authorizations. 32310, for those of you who have large capacity magazines, be aware, those are prohibited. And let me get that delayed effective date for you on that one. That's 32310, the Penal Code. Again, Prop 63, page 211, starts July 1st, 2017. You cannot possess a large capacity magazine. Of course, if you fit one of the dozen exceptions out there, mostly law enforcement, you'll be fine. But the stated purpose in Prop 63 was to get it out of pretty much everyone's hands but law enforcement. So that's an infraction, actually it's a misdemeanor crime. Could be an infraction or a misdemeanor depending on how we decide to charge it. And if you're not grandfathered in on this, if you've got a large capacity magazine, which you can legally possess today, for the next 18 months, you have to dispose of it in one of these ways before July 1st, 2017 by getting it out of California, selling it to a licensed dealer, or surrendering it to law enforcement. Let's go to the Vehicle Code, just a couple things there to talk about. If you're concerned about texting and driving and handheld devices and all that, there's some new information here. We're going to go to page 226, talk about Vehicle Code 23123.5. And this actually repeals the crime of texting while driving. It creates something new and a little more cumbersome. And this is the crime of driving while holding and operating an electronic device. It's not limited to texting. It's everything. It's texting, web browsing, GPS, navigation, apps. So if you're driving along holding your device, it doesn't have to be a phone, holding your device and doing something on it while driving, you're in huge trouble. Although maybe not, because the base fine is only $20 for a first offense and $50 for a subsequent offense. So there's your new infraction crime. What's interesting is, here's how you can do it safely and legally. And if you do it one of two ways. Either you've got your device mounted on the windshield of your car, like you would a GPS system, or on the dashboard, and it's not, impeding your view of the road, and your hand with a single swipe or tap with a finger can operate this thing. But to me, that's really hard. This thing's on your windshield, and you're trying to swipe and tap and drive and make the turn. That seems really bad. So anyway, that's how you can do it legally. My advice is put your phone in your purse like I do and turn it off. That's the easiest thing to do. It really is. Now, we still have 23.123 of the vehicle code that prohibits using a wireless telephone unless it's designed for hands-free driving. And we still have 23.124, which prohibits minors from driving and using wireless devices, even if they're hands-free. Minors can never do that, so keep that in mind. 23.152 and 23.153, we will talk about them together. DUI and DUI with injury. Starting July 1st, 2018, we have a new subdivision E, which prohibits these passenger-for-hire drivers, Uber, Lyft, taxi drivers, from having an blood level alcohol of 0.04 or greater. That starts July 1st, 2018. But because E has been added into these two DUI sections now, and it dropped E to F and F to G, we'll be using the new F instead of E and the new G instead of F right now for those DUI crimes. So driving under the influence of a drug, which used to be E, is now F. And G, which is prohibiting both the driving under the influence of alcohol and or a drug, was F and now G. So we should still use those new subdivision sections, but the E, which is in there now, won't be effective until July 1st, 2018. Ignition interlock devices. I just want you to be aware this is not coming up until, we're on page 229, not until January 1st, 2019, a 2-year delayed effective date on this. What it does is it eliminates the pilot program that was operating in about 4 counties that required all first-time DUI offenders to install ignition interlock devices. And starting January 1st, 2019 until January 1st, 2026, everybody, all counties, no matter what offense it is, you have to install ignition interlock devices for DUI crimes and for 14601.2. So what's going to be very confusing when you get your penal codes next month is you will see many of these sections, the license suspension sections and this 23247 and 23702 have 3 different versions. You'll see the version in effect until January 1st, 2019. You'll see the version in effect for 7 years, from 1/1/19 to 1/1/26. Then you'll see the version that's going to be effective and take over January 1st, 2026. It's going to be very confusing for all of us because there's so much out there. It took me, I probably spent a day on that one too, just trying to figure it out. Let's go to page 235 and talk about the W&I code. That's 4146. And actually, we already mentioned that one in the context of compassionate release for the mentally disordered offenders, the not guilty by reason of insanity folks, and the incompetent folks. So you already know about that. Last item is on page 236, and that is 6601 of the Welfare Institutions Code. And that is, this requires the State Department of State Hospitals to give us at least 20 calendar days prior to an inmate, to give us notice, 20 days before an inmate's going to be released, so we have time to file a sexually violent predator petition if we wish to do so. Apparently in many counties, I don't know if we have this problem, we get notice way too late to be able to look at the case, decide what to file the thing, and get the defendant transported to our county. So now, no fewer than 20 calendar days prior to the scheduled release date, or prior to the expiration of the current hold, they've got to give us notice for the request to us that an SVP commitment petition be filed. And that is it. Thank you all, and it's 5 minutes to 5.